Hello, welcome back to SQE1, and we have a chapter that focuses on settlement overview. So first, let's look at negotiated settlements we will try to talk about. So what are negotiated settlements? A settlement should always be clear in scope, recorded in writing, and cover who pays costs. Pre-issue settlements usually come from ADR process like negotiation or mediation. If you want to enforce a pre-issue settlement, remember, you must prove the terms in court. Often a tricky point for exam. Post-issue, it gets more formal. You must notify the court in writing if one or more parties are legally represented. A consent order or Tomlin order is needed. So this Tomlin order is examined and we will talk about it. These make the settlement enforceable and avoid reopening the same dispute before court. So the next thing is consent order. Consent order are simply court-approved agreement between parties, usually for payment. They are legally binding contract, so if breached, the innocent party can start fresh proceeding for breach. Key point for your exam, they must include the payment sum, time scale, usually 14 days unless otherwise stated, and how costs are handled. Also, the order clarifies the claim status. Is it stayed, discontinued, or dismissed? A stayed claim can be enforced on application without issuing a new claim, whereas dismissal requires starting it over. To save this, to start it over, there is Tomlin order that is examined sometimes. Tomlin order are a special type of consent order with two parts. The body of order stays proceeding on agreed terms and provides for any money or cost in court. Importantly, the court can enforce the schedule if breached. The settlement terms themselves remain confidential, often in a separate schedule or agreement. The court can vary the body but not the terms. So Tomlin order are frequently used in litigation. So the tip is, especially for sensitive claim, they are used. Like those involving children or protected parties, keep in mind confidentiality is a key exam point here. The Tomlin order stays the proceeding, does not finish it. You can start it over. Number two, it remains confidential. So a claimant can discontinue proceeding at any stage, even during trial. However, they will usually be liable for the other party's cost unless the court orders otherwise. The case is Nelson's Yard is a good one for you to understand. So once you start a proceeding and you just run away from it, you need to pay for other parties' cost. Common reason for discontinuance is the defendant can't pay it. It's no longer worth suing them. And also there is another reason that there is weak likelihood of success. The usual procedure is to file and serve a notice of discontinuance. The defendant can challenge it within 28 days, but this is rare, very rare. Always remember to check if court permission is required, particularly in multi-party claims. So another thing that is exam tips, we always talk about it. Always distinguish between pre-issue and post-issue settlement. Both of them are two different things. They often test your procedural understanding of it. Know the difference between consent order and Tomlin order, especially regarding confidentiality and enforceability. Understand continuance rules and when court permission is required. Beware of not continuation, discontinuation rules. Beware of costs applications. Incorrectly assuming costs are not relevant is a common exam trap. Master these points and you will be very confident in your exam. Thank you very much for your time. I hope this helps, especially Tomlin order. Don't forget it. So, ta-da!